Hey Alison, I'll try and make this really quick because I don't want to talk for ages because I know that I end up going on and on for ages. But listen, right, so it doesn't matter whether it's a supplementary question or not. I don't think this comes down to the council rules or council procedure or council policy or the standing orders of the council, right? Because the standing orders of a council or parliament cannot actually go against legislation itself, an act of law. And that's why councils try and get the law changed. That's why they put private bills or pursue getting bills put through Parliament to give them more powers, right? Because they don't have that power because of the act of law, right? It gives us, the people, a statutory power. Now, I've been focusing on the Public Meeting Act 1960, right? Which the council, if they don't want to have the public present, right, at a meeting, then no one's present. But when they do have people present, then everyone has to be able to be present and speak. It's like all or nothing. And it is privilege. It's legally privileged. So you can't be prosecuted or have any charges brought against you for speaking as long as it's not in malice. But in the dictionary, malice means without cause. So if it is in any way pursuing or in connection with, the business that is in front of the council, you can say what you want, which means that, if you are angry or upset, you can actually effectively swear because you've got freedom of speech as long as you are swearing about the issue and expressing your feelings about the issue. Obviously, if you were to swear and express your dissatisfaction about someone, selling an ice cream outside, that's nothing to do with the business in the council, right? But if due to what the council are doing, you're extremely upset and furious, you can say that, you can use swear words to express that because it's concerning that matter, right? That's what privilege is. Now, this is the thing, right? There's another Meeting Act as well. There's not just the 1960 one, which gives us privilege in Parliament, right? In that act, the council they don't have to have the public present, right? But if they do, then everyone has to be equal, or it's not a proper. This is what due process is. If you have all the public there, everyone has to speak. This is what democracy is. Now, there's another act. There's the 1908 Public Meeting Act. And that applies to all public meetings, not only local councils, but any meeting that anyone has, like even in a business meeting, or if the public come together in a park to have a meeting about something, the public, in law in England, right, the public are allowed to assemble, right, and meet and discuss anything, and the police can't break them up as long as they're not breaking the law. And if it's a parliamentary matter, you add in parliamentary privilege on top of that, and the police cannot break them up because it's under the jurisdiction of Parliament, right? Now, this is the thing, right? The 1908 Act also applies to a council meeting as well as the 1960 Act, right? And because the 1960 Act added the privileges for local council meetings to the established law. Now, what is the established law? Well, actually, this goes all the way back further than the Bill of Rights, right to petition, right back to 1368 is when the public, the community, are allowed to assemble, right, to put their grievances to the King or Parliament. But that can be the local council chamber because they're acting on the authority of the King, right? With the mace, that's the whole point. It says that in Erskine May, right? The King is present in the council, right? This is a fact. If that mace is in the council, right, the King is present. It's the King's presence. So you've got the right to petition the King. Now, that is like the observation of due process of law where the community can come together. They don't have to be in the council because they might go directly to Parliament. But actually remember that this is really important. Up till 1986, right, if you were having a large number of people, you had to get judges to give you permission to go to Parliament, and usually it would have been the council who gave you permission, right, to petition Parliament, because you'd have to get it signed off by 3 judges, which could have been the mayor and 2 of the aldermen if they had authority, right? Because the council would sign off the petitions to Parliament, and this is what the council are completely oblivious to, and why they need to educate themselves, right? And this has got nothing to do with them. It doesn't matter what the policy is at the moment. It doesn't matter what the standing orders is at the moment. These are laws. This is legislation, right? This is statutory powers, and these are really important ones. That the 1688 Act, the 1661 Act, this Tumultuous Petition Act, that's repealed now. You don't have to go to the council. That's why the council are oblivious, because the council don't really know anything about these laws, or they're not interested in them, right? So the 1908 Public Meeting Act, that would have been to actually supplement the observation of due process of law, right? Because when we go into council, when you go into a council meeting, right, you're following the observation of due process. It's due process of law. It's not any different to a court, as county court or a criminal court. It's just that the type of court it is a local council chamber for local civil matters, right, which have to get ordered by the council, whether they get approved or not, right, in favour or against. It's still observation of due process of law, right? Now, in a normal court, you can have, like, the prosecutor can object to certain things being said and so forth, right? But that's not actually the judge, right? That's the actual prosecutor, the opposition, and it's only an attempt. It's only an attempt to object to it, and the objection has to be like to say that, oh, I don't think this is relevant or anything like that, right? And things like that. If the question is relevant and to do with the business, then it's not. You can't object to it. Now the thing with this is a thing, right? A county court and a criminal court, although the public have got audience in the gallery, remember, right? In the court, the public are come in. They're allowed to watch. So really, it is the public watching. And actually, this is actually quite important, because this is what I've been saying the whole time. And it does say that if it's not like when it's a private crime, when it's an offence by one offender, right, they've got the right of audience and their legal team, right, or appointed legal persons. But when you've been acting on behalf of a body or on behalf of a group, all of that body or group can speak in the court, right? And when you're doing like a petition or a political campaign, you form the body. Where is that, right? Well, and one place it is if you look on the Court of Protection, you've got the form COP 10. What does COP 10 do, right? COP 10 joins parties as a body legally, right? For many different purposes or matters, like someone might not be competent to represent themselves, right? So you join yourself to them so you can act as them for them, right? Like if it's disabled or something like that. But you can also join a charity group together and they act as one body. So if they're having a legal motion or action, they all have equal address, right? Now, you don't need to do that COP 10 form to merge parties as one recognisable legal body that is recognisable by the courts when you're doing a petition, because when everyone signs the petition, they're joining themselves as a body, right? So in a criminal case, if it was a protest and they're all signed to the same petition, actually, if the other people turn up in the gallery, they really can speak. And this is something the courts need to get their head around, because I'm not wrong, I'm right. And in the council, right, I would suggest that, this is my opinion, right, if the council are asking the public for their opinions, right, and this is the thing the Court of Common Requests is not it's not a private matter for one individual, right? It's a public matter. Also, the public wouldn't have a right to make a representation. If it was a private matter, then no one else would have a right to make an appearance or say. The fact that multiple people from the public, right, can appear and speak. Why have they got a right to speak? Because the council are asking the whole public for an opinion. And when they all make a submission to the council through the objection form and applications forms, right, they're all joining as a party because they're all giving an objection in the same matter. So they're all merged and joined as a party, right? So really, when anyone has a legal right to make a submission, right, in the council, it is under the Public Meeting Act because it's a local public matter, like whether it's the ward or the whole area or town. In fact, the council, as a court, right, as like the modern version of the Court of Civil Requests, whenever you've got a right, whenever they ask the public, you know, for a consultation or anything like that, you're always merged as a party. You're always merged as a body, right? So you are using that Public Meetings Act because everyone's got a right to attend. And that is what the 1960 Public Meeting Act says. If the council don't choose to have people present, then no one has a right to turn up and speak or be privileged. But as soon as they do, then everyone has got a right to speak and transact their information. But that is a statutory power in law under the Public Meeting Act 1908, as long as they're acting lawfully, as long as they're not acting illegally or criminally, right? And that's where the 1908 Act says that as long as you don't prevent anyone else from speaking, right, and as long as you speak in order and don't cause a disruption, and I don't think that merely shouting out and swearing is a disruption because you know, you might not necessarily be, that doesn't prevent, you know, proceedings from continuing, right? If you obviously started jumping on the tables and stuff like that, then you couldn't continue. But, you know, just because you shouted something out isn't like, it's not preventing them from continuing or anything. You know, like if you took all the chairs out or something stupid like that, you would be stopping people from being able to sit down or whatever, right? Or if you block the doors, that's disrupting proceedings, right? Stopping people from going to the toilets, stuff like that, right? You know, or, you know, putting gagging the gagging other people, like putting your hand over someone's mouth next to you, right? That's disrupting proceedings, particularly if it's their time to speak, right? Actually stopping another person from speaking is disrupting the proceedings, right? Because everyone has, as long as you don't stop anyone else from speaking and you don't prevent the proceedings from continuing or disrupt them to a level where they can't continue, right? You know, it's not just a matter of a simple misbehaviour, because the misbehaviour might not actually disrupt proceedings. You might commit a different offence, but it's lawful. It's always lawful when it's privileged, right? The 1960 Act adds privilege to it. So as long as it is pursuing the objectives of the meeting and of the matter at hand, the case on the table, the application or the submission, as long as you are speaking or acting in pursuit of that or in relevance to that, it's privileged, right? It's not with malice, because malice is without a cause. So as long as you're speaking in pursuit of the cause or on behalf of the cause, right? Like, you know, if you're upset or angry, you've got a cause to be angry if the application is upsetting you, right? You've got a reason and cause to be angry if, you know, someone's going to, bulldoze your favourite park, right? You've got a cause. You're with cause. You're attending with cause and alarm and distress in response to the action. This is all in pursuit of legal proceedings. This is all the similar type of law that justifies, you know, police kicking doors in and all this type of thing, because it's not a private offence, a private crime. They're claiming that they're in pursuit of something. They're in pursuit of a process or cause, right? Now, so the 1908 Act, you have got a legal statutory power to transact your material information at that meeting, right? And you can't be stopped. In fact, it's a criminal offence to stop you. So if the councillors prevent you from putting a question or speaking, that is a crime. That's the crime. You don't know what the crime is, because if you're at a lawful meeting, right, and you are prevented from speaking and transacting evidence, that's an offence. That's what you've got to realise. That is the crime against you. And it doesn't matter if they're the chair or not, because the whole point of a public meeting is to everyone to come together and have their say. And that's what the 1908 Act was created for, to make sure that everyone could have a say at the meeting, because that's the point of having one, right? And any person, the only offences in that act are if you disrupt the meeting or prevent it from continuing, right? Or prevent other persons from transacting information. Now, this is why, like, in a court, in a criminal court, the prosecutor will object, right? He might object, but he can't object. What he's actually doing is he's trying to make out that what you're saying isn't relevant or is pointless or isn't, it's nothing to do with, like, the matter at hand or something like that, right? They're not allowed to object to it when it needs to be said or if it's something to do with it. Now, what did the council object to this question on, right? This is the thing, and who says? Now, they could be committing a criminal offence, and they could be prosecutable, but the thing is, it's meant to be privileged. So, if they're trying to make out, right, that it wasn't relevant, you probably can challenge them on that with the monitoring officer. I would have thought that there's probably some legal challenge you can do. Like, all right then, so, like, if it's in the court, you could probably complain to the Judicial Conduct Investigation Office, right? If you're in a court and the judge, prevented you from putting a question or whatever, or if the prosecutor raised it and the judge agreed with him or whatever, that is something that you can complain to the court about, or you can complain to judicial conduct about, right? You can complain about the conduct and behaviour of the judge, right? But it probably might not affect the case, but, this is what the monitoring officers are. But what was the question? What was the case? What was the cause? What was the council? What was the matter before the council? What was the issue before the council? And what was the question, right? And I actually think that it's likely that there probably is something that the public could themselves say or do if they know the law, right? Because what is the question, right? For example, right, let's say, like, the person somehow can tell everyone else in the room, what his question is or was, right? If there's a break or a recess or something, I don't know. And then you see, people could potentially raise their hands up and say, we think the question is relevant, right? And challenge the judge, because you could do that in a court. Another person, because that's the thing. Everyone else in the room, right, when they speak, when they've got a right to speak, they can give their opinion on anything that is presented or being said or done or for the proceedings. So the other person's question, which might have been objected by the council, the other people have got a right to say, actually, we think that question is actually relevant, and they could say, and the people, I would have thought if it was the council compared to the, this is when, like, you do need to look at the rules and the regulations and the policy and the standing orders. But what I'm saying is there is a statutory power in law that says that if you stop someone from speaking, it's a criminal offence, right? And this is where I think that the councillors probably assume that, they've got some kind of, everyone turns up and, generally everyone's got a right to speak, but if the councillors want to stop them, they've got some sort of judicial power to prevent it. But only on certain circumstances and conditions, like, if they can prove or show it's not relevant. Did they say why or how they thought that it was not relevant and justify that? Because if it's a local council, I would have thought that the other councillors could actually have a vote on whether the question was or was not relevant. I would have thought that what you do in that situation is somehow like, the person with the question would then say, address the councillors and say, I think my question is relevant on this point or that point, and then I would have thought that the other councillors there could have had a vote on it. But if they don't vote in favour, then this is the thing. It's a statutory power. What I would do is I would voice that. I would say, excuse me, right? Mr. Chairman or whatever, Mr. Mayor, I would just say, excuse me, this question is relevant to this meeting for this reason or that reason, to establish this or that. And by the way, unless you can prove otherwise or you have any evidence contrary to that fact, then it's a legal statutory power in law. If you prevent me from speaking in this meeting, it is a criminal offence. You are committing a criminal offence contrary to the Public Meeting Act 1908, and you are preventing me from speaking in a public meeting where I've got a legal statutory power to transact information. Now, if you object to my question, can you give me a legitimate reason why? What is a legitimate reason, right? And then at least then, what then you've got is like the public record, and then, this is when, you see, this is what I don't like about complaining to monitoring officers, because this is the thing, right? Everyone who was attending that meeting, or even the whole public, right, has a legal right then to petition the council in complaint to that question being objected to, right? Because that's what petitions are for, grievances, and everyone's got a right. Now, the problem with complaints against councillors and persons in the council is this, right? Usually, complaints nowadays are done by individuals or and no one else sees them, right? No one else sees the complaints. So usually only the monitoring officer sees it, right? I know that certain ones have to be published or certain reports have to be put out. But generally, a lot of people don't look at those reports or don't look at the complaints and so forth, right? I don't know what the exact procedure is like, but I know generally that there might be some kind of, or you can put freedom of information request in or something like that. But what I'm saying is, right, the traditional method, really, when you've got complaints against MPs or councillors and so forth, is that people can... The petition is the complaint, and the more people who sign it and the more people who know about it, then there's more pressure or more incentive for the council to act and do something about it, because then more and more people won't be happy about it. But when you get this culture and procedures where either people don't see each other's complaints or don't look at them and people don't know about it, then there's not any... They can just bury them or, sweep them under the rug or whatever. This is the thing. And this is the problem. This is the exact problem with the e-petitions at the moment in Parliament, right? They're only allowing e-petitions about amending and strengthening the laws, right? Yet, it's meant to be there so you can complain about grievances, about evil ministers as well. But they're not letting you do it. Because they don't want everyone to see it and everyone to sign it and everyone to support it, because then it makes them do something about it, right? And they call it scandalous or vexatious or frivolous, or they call it defamatory or whatever. But if it's a legitimate claim and true, or you've got a strong evidence, then it's not. You've got a right to do it. Now, this is the thing. Complaints to the Ombudsman aren't about MPs. They can only be about different departments, but they can be about malpractice in different departments, malpractice and behaviour of staff. But the MP still signs it off, but it's not about MPs. But Parliament are trying to make out that there is no method to complain about MPs, because they're privileged. But there is. You can't get action against them in a court or tribunal or placed out of Parliament, because they don't have the jurisdiction to, right? Unless they committed a private crime, right? Personal private crime. In Parliament, it has to be petition to Parliament because you can't get anything done about it anywhere else. This is why the election petitions used to be to Parliament until they allowed them to be heard by the courts. So the e-petitions are currently blocking complaints about MPs, right? Or they're saying, sometimes they say do it in paper, but the electronical form was meant to complement and be for the same purposes as paper, but they're trying to make out that it's some special, traditional process for certain things, but it isn't, because they said that they were going to have it for the same purposes. So they're just blocking us, and this is my current battle with the e-petitions committee. They're lying, and they've got all these policies, but the policies contradict the standing orders and the law. The standing orders say that they've got to do certain things like, summon people to get more information, right? But then the policy says don't question people, don't ask them questions, right? So the policy actually is an attempt to block the process, to obstruct it, but illegally because it goes against the standing orders. So this is the thing. Now, when the council are doing things, they've got to comply with the law, the underlying law, right? And then all of the standing orders of the council have got to be compatible with the law and comply with the law. And then when they make policies as well, in addition to standing orders, the policies cannot go against standing orders or say don't do something when the standing orders say do it. So it's only a policy. It's actually meant to complement and it's meant to go along with the standing orders, not go against them or against the law, right? So all of the standing orders of the council and the policy has to be compatible with the Public Meeting Act 1908 and the 1960 Public Meeting Act as well. Now that means that everyone has it's not actually giving you the right to speak, because it's actually making it illegal for someone to stop you from speaking. That's what it's doing. It's not saying that everyone's got the right to speak. The Public Meeting Act 1908 is saying that if you stop someone from speaking at a public meeting, you are committing a criminal offence in law, no matter who you are, right? As long as that person is not preventing anyone else from speaking, obviously in their order or whatever, or disrupting the meeting from being able to continue, right? If you steal the chairs or lock the doors or, put masking tape over everyone's mouth, then you're disrupting the meeting, right? But, maybe if you did just, do a misdemeanor or something, that might be an offence in itself, but it might not substantiate you from being removed from the meeting as long as you're not preventing the meeting from continuing, right? This is the thing. This is what the chair is meant to be management of a meeting, right? That's why they shout out order, order. This is why the Speaker in Parliament shouts out order, order, Doesn't necessarily throw them out. He tells them to shut up or whatever. But that's parliamentary privilege of free speech, but it's self-governing and self-regulating. But you see, the Public Meeting Act might not apply in Parliament because it's common law. So the MPs might say that, they're privileged not to have the Public Meeting Act apply. But there's certain laws that we've got to submit petitions and grievances to Parliament, but how they're debated and discussed is kind of like managed under the Speaker's jurisdiction and authority. But in the local council, it says it's privileged, and the local council isn't Parliament, right? So the local council is subject to the common law, right? So therefore, I would say that it is illegal. It's a criminal offence to prevent anyone else from speaking or transacting information, unless it is with malice, which is probably why they brought the 1960 Act in. They probably brought that 1960 Act in to say that it's privileged except for malice, to help clarify on the 1908 Act for additional context and clarity on it. I would have thought it makes sense to do that, and that's what it actually does do if you understand it properly. So I would have said, you would, if this are not allowing your question, then you need to. You're being tested. They test the juries in courts. They test the jury. They challenge the jury, right? You've got to be able to stand up for yourself, right, and say, "Excuse me, on what basis do you object to this question, right?" And then if they say, "Well, on what basis, or what reasons do you object to it for?" And then you say, "Well, I give these reasons why this question is valid." You go argue. You got to be able to stand up for your question and argue it, and know that. Well, I'm sorry, but unless you can give me a reasonable or legal, unless you can, prove that my question is irrelevant or illegal or whatever, or it's with malice or whatever, then I'll have my question and I'll put it, right? You got to know what the law is. And in fact, may I remind you that unless you can give me a truthful, legitimate reason why my question is not relevant, right, always with malice, then I may remind you that you're committing a criminal offence against me, right? And I'll have to call the police in, right? Because you're breaking the law. You're preventing me from transacting information in a public meeting, right? So this is the thing. This is when you call the police in. This is what the police are meant to actually be doing. Right? No, just like the council call the police in, the council call the police in. The public are going to be able to call the police in, right? This is the thing. So, but this is why they said that it's privileged, right? They're saying that it's privileged. So, that's a good question, is, but I would have thought it's privilege from what you say, right? This is to do with privilege from defamation, libel, or any harassment, blah blah blah. All these any offence which involves the effects of what you just said, on other persons. That's why it's privileged, right? You can't be prosecuted. The people participating can't be prosecuted about what they said, or if what they said, gets reported or put in the newspaper, they can't be prosecuted, right? But we're talking about the actual proceedings. Now, the 1908 Act, they didn't repeal it with the 1960 Act, so I would have said that it's still enforced, therefore. And that's what your privilege is. Your privilege to speak, right? So, it's still enforced, that 1908 law, and I would say that if you are prevented from speaking, that is a criminal offence, right? And you're only breaking privilege if it's with malice, and so forth, unless they, if it's not relevant or whatever to the objectives of the kit of the cause thing, but I don't think that court proceedings are privileged. I haven't seen anything which says that the court proceedings are privileged, but they're privileged to that court. But then you've got all these contempts and so forth. I don't know what contempt of the court is. I would suggest that this is my opinion, right? Because, the council primarily deals with the public attending, so it's always a public meeting, right? Whereas criminal and civil cases aren't necessarily public meetings, but the public are present. But unless you can, claim a right to speak, like needs of other cases or something like that, or unless you are claim that you're a party or you've got a right to speak, the public are present and watch and observe, but they don't necessarily speak or participate, right? But in a council meeting, they do have a right to speak and participate, and that's why it's a public meeting, and that's why you've got a legal right to transact, and you don't have people can't prevent you from transacting, which is why it's a little different to contempt of court, right? Well, that malice, if you raise that malice, if you break that malice provision, then they probably can say you in contempt of the council meeting. If you break that malice clause in the 1960 Act, then that's like you can have something done against you. So that's like the equivalent of the contempt of Parliament. Now, there are other rules. There will be proper rules for the council, right? But what I'm saying is, those rules for the council, I know that they will, when you look at them, they will, and they're supposed to be completely compatible and in line with that 1908 Public Meeting Act and the 1961. They will be, and I know that for certain without looking at them, right? So we're only going down to policy, which isn't the law. So this is just like councillors knocking stuff up, cobbling stuff together themselves, but, do they have a legal right to do that? It's just a policy. It's not the standing orders, which were voted through in the proper official rules, or the legislation, right? So I think it's a criminal offence to prevent someone from speaking in a council meeting unless it is malicious and not with cause. It's not in pursuit of the the business. But if it is in pursuit of the business, then you are allowed to shout and swear if you genuinely are, if that's your genuine response and evidence and statement. Like if you're upset, then you got a legal right to be upset. Because that's the whole point of it being privileged, or there's no point having it, right? So it could. I don't know what the question was. I don't know what the question was that they put to the council, or, what the reasons were why they objected to it. But this is the thing. You go argue. This is the thing. This is why solicitors or barristers are trained to be admitted to the bar in a court, because they're meant to be able to handle themselves, respond, know what to say. This is why when you're taking on the Crown Prosecution Service, right? Now, if you go into a court and you're coy or you're not confident and you don't know any rules or procedures and you haven't read them, and, the CPS might be breaking the criminal procedure rules and so forth, I was fobbed off when I went into court because he's trying to shut me down so I couldn't say what I wanted to say. And so forth, and that's why it helps to know all of the procedure rules and to know all of the law, so then you can have the confidence to call it out and challenge them. But it depends if you've got what judge you've got. I had Watson and he was a complete imbecile. So, and the legal advisors aren't always necessarily very good. Magistrates don't know the law. They're not legally trained. I mean, they're familiar with the processes of the court because they work in them all the time, right? The magistrates, but they're not they're not qualified lawyers, the magistrates. This is why when you submit a lot of legal stuff, you don't always win. Or many times they just, don't necessarily think you're right or believe you. Sometimes you could just submit it through the post and win when you're correct. But magistrates don't like that. They like to get you in and get you in front of them, and they like to, if you're a QC, a barrister, and you say it, then it's usually you're usually taken to be right and respected and upheld. And if you submit to a magistrate, if you say this, then it's, the magistrate kind of takes it more seriously. Whereas if you're just a member of the public, right, and you submit a defence or whatever, some people are, everyone's different personalities and characters. Some people can just go into a courtroom, and they might be able to just, it does depend a lot on who the judges are as well, but you hear these reports of people going in and representing themselves, right? They represent themselves in court and win. But maybe they were comfortable in there, maybe they were confident, maybe they weren't scared. The problem with criminal matters is this: you're always defending yourself. If you self-represent, you are under immediate threat of, suffering, being prosecuted, right? So there's a lot of urgency and necessity and alarm to it. So it's almost like, if you're being sent to war or something like that, but that's what you get your training for, It probably would be better if you're in a court and you're not being prosecuted, like if you're helping someone else or representing someone else. But that's the thing, you're not allowed to represent someone else unless you're a qualified barrister or a lawyer, right? Well, no, you might be able to, if they're not paying you money, if you're not doing it for a profit, for money. But there are certain different rules that they've invented now, like you can have like a confident friend there to support you and stuff like that. But this is what Jonathan N. Fuller was doing. He was wanting to represent for Extinction Rebellion, and they wouldn't let him. But he ended up being able to speak in the court, but not address the court or the judge. But the Extinction Rebellion have got it wrong, because they are all signed to and subscribed to the same legal cause as a body, like under COP 10, but it's not COP 10, because when you're doing a petition to the Parliament, right, you're merged as a body. You don't need to fill a COP 10 form in to join parties together for the courts to recognise it, but the courts aren't recognising that they're doing a petition to Parliament. This is why you've got the petition of leave of court, which in 1980, a lot of it was withdrawn. So the courts didn't have to get Parliament's permission to mention certain reports, papers, committee reports and things like that. Obviously, they can mention the law that Parliament makes in a court, or you won't be able to have a court session if you couldn't mention the legislation. How can you do law in a court if you can't mention the law? But we're talking about like committee reports and things like that. You had to get permission from Parliament, but if you've got a petition case with Parliament, it is a Parliament thing. So you have to have leave of court to mention it, but they're not doing it actually. You've still got to mention certain ones. And that is where the courts currently are utterly and completely in defect. They're wrong. They're in error. In fact, they're in contempt. Because they're actually talking about and mentioning that the proceedings and the messy civil things that people are doing in their parliamentary cases, what they're getting prosecuted for. And in fact, the courts were trying to tell them that they're not to mention it, right? Well, the reason why you mention it is because like it exists and you got it, right? The council did have a role to play in this in law before 1986. When that 1661 Act was repealed. But no one was using it. I looked into it. No one was bothering using it because they weren't actually enforcing it. The suffragettes weren't using it because the courts they stopped bothering to ask them to bother using it, right? So they were kind of letting them... they weren't enforcing that law, right? But really, when you're in the council, right, and if you've got, something to do with Parliament, you need leave of council to mention it or whatever, and that's why the councillors, when some of them were judges, like the mayor and the chair of the council and the alderman, they had to sign it off. They put the council stamp on it, right? If you wanted to get, to ask, if you wanted the case to Parliament, it had to get sealed off by the council or 3 judges. But the council were judges at that point, right? So they would sign it off to Parliament. And that's why I think that if you disagree with the council or you're not happy with an order that the council made, you're meant to be able to pursue getting a private bill put through Parliament to oppose the council on it, or to get legislation to give you powers to stop the council from doing it, right? Whatever. And when big companies do this, that's why they get the parliamentary agents to put private bills through. The council do it themselves. They seal stuff off. Some councils want to give themselves more powers, right? And they have to seal it off and stamp it off to Parliament. It's from the council. It's a petition of the council to Parliament, right? But this is the thing. This is where the 1908 Act, it's a power, gives the public a power, says that if you're engaged in a public meeting, that it's unlawful, it's illegal for someone to stop you from speaking, right? Unless, according to the 1960 Act, if you committed malice, you're a breach of privilege. So if you're in a breach of privilege, then, probably, but still then, it doesn't actually say in the 1908 Act, it does not say that what the information is that you're transacting, right? Because, and you might find this funny, but this is complete truth and fact, right? If you're in a council meeting, right, and you need to go to the toilet and, you know, you need to somehow ask permission or be excused, right? I don't know if you can just leave anyway or whatever. Anything like that, going to the toilet might not necessarily, you might not say that it's pursuing, you know, an objection to the application or anything relevant to the case. But this is your other rights, you know. This is like when you're in a court, if you have an accident or emergency, and you've got the overriding objectives, you know, the rights of the defendant, the rights of the people participating. Like, you got the right to go to the toilet, obviously, right? Yeah, that's not a comment which is relevant to the proceedings of the council, right? But you know, you got a legal right to, you know, be excused to toilet. It's not malicious, you know. So, but have you got the right to say it? You know, have you got the right to speak? This is the thing. If you're up at the council speaking and giving evidence, and you're absolutely busting to right? You have to say, "Excuse me, I need to go to the toilet," right? You know, put a question. Can I put the question? Can I please go to the toilet? Right? You know, object. You know, they can't overrule that, because under the overriding objectives, the rights of the defendant, you actually got a legal right to go to the toilet and ask if you're allowed to go to the toilet. That is an overriding objective, right, of a right. So if you really need to go to the toilet, if you're going to wee yourself, right, and also for hygiene and safety, right, you can put that. That's a question that you can put in the council, and they can't object to it, and they can't even object to it under malice rules of privilege, because it's an overriding objective. Now, the thing is, like, I don't know if the local council has overriding objectives, because they're in the criminal and civil procedure rules. I don't know if the council proceedings fall under the civil procedure rules, or if they're separate. There's likely probably some sort of policy for it, but no, does the policy follow standing orders, and does it follow the law? But this is like, what's it all built on? What is the legal framework? Well, the legal framework is that it's a criminal offence in a public meeting to prevent you transacting information, right? It doesn't say what the consequences are after you have said it, right? Or of you saying it. Now, that means that they can't stop you from saying something, but if it ends up being malicious, then, you know, you're in a breach of privilege, right? But it actually says that you're allowed to transact the information as long as you don't prevent anyone else from speaking, and you don't disrupt, you know, the proceedings to an extent where they can't continue, right? Now, surely, you know, if you've got, you know, Tourette's disease or something, and you shout out, you know, like that, or something like that, it might be alarming to people or so forth, but, you know, it doesn't necessarily prevent the proceedings from carrying on, right? You know, I mean, if you do it a few times, then they're going to get annoyed, you know, tell you to shut up. Maybe they might ask you, you know, to go outside until you're quieting down, or, I don't know, you know, good question. But obviously, if that's a medical thing, they can't stop you. That's another example. If someone's in a council meeting and they've got Tourette's, they've got a legal right to be there, right? Someone in a council meeting with Tourette's has got a medical right to be in there, and it's not to be regarded as malicious, right? If they've got genuine illness. So that's like just another example, you know? I would challenge, you know, that the 1908 Public Meeting Act needs to be voiced, used, and enforced. And you got to challenge them on it. You got to say, you know, what is the reason for your objection? You know, can you justify what's the reason for the objection to my question, right? And then part of the legal rights is the right to you've got the legal right to justify and explain your question, right? So you got to try and exercise that, and make sure that you do try and exercise it, and that you challenge them. This is what this is kind of like sort of like in the same kind of area of like testing a jury, or like if a prosecutor makes an objection, right? You know, objection overruled. You see, to get the objection to your question overruled or whatever, You got to, you got to give reason. You got to be able to reason your question or justify it, right? You got to be able to do that and tell them that you've got the right to do that. That's the thing.